Good morning. My name is Brett Scharfs, and I am a professor of law at Brigham University Law School and the director of the International Center for Law and Religion Studies at BYU. On behalf of our co-organizers, the Center for the Study of Law and Religion at Emory University Law School, the Notre Dame Program on Church, State, and Society, the Center for Law and Religion at St. John's University Law School, and the Eleanor H. McCullen Center for Law, Religion, and Public Policy at Villanova Law School, I would like to welcome our global audience to this webinar on law, religion, and coronavirus in the United States, a 6-month assessment. Thank you for joining us for what we believe is going to be a very rich and rewarding, not to mention densely packed 90 minutes. In August, the organizers thought it would be interesting to put out a call for proposals for blog reflections on how things look from the perspective of law and religion studies in the United States 6 months into the coronavirus pandemic, especially with its ancillary economic crisis, the racial justice crisis, and the pending presidential election. We were astonished with the quantity and quality of proposals we received, and we selected 25 to be a part of this event. I want to thank each of our contributors. Our plan this morning is for each of these 25 authors to summarize their blog posts in no more than 3 minutes each. Our hope is this will whet your appetite to read the longer blog posts, which will be simultaneously posted on the blogs of the 5 sponsoring institutions at the conclusion of this webinar. Some centers will post all of the blogs and some just the blogs from their panels, but there should be links to the full set. We have divided the program into 5 panels, each of which will be moderated by a scholar from one of the sponsoring centers. The program is on the landing page for this webinar, as are biographical sketches of each of the speakers. To save time, we will introduce each speaker only by name and institutional affiliation. So please check out their impressive biographies online. We have also asked our moderators to be quite strict in enforcing the 3-minute per speaker time allocation. We are very grateful for the 25 scholars who are participating with us today, and very grateful to each of you for tuning in for this webinar. We are pleased to have such a distinguished and diverse group. While we don't expect to agree with each other on every point, we are grateful for the opportunity to gather and listen together. Without further ado, let me introduce Jane Wise, an Associate Director at the International Center for Law and Religion Studies, who will moderate our first panel, focusing on constitutional law perspectives on law, religion, and the coronavirus pandemic. Professor Wise.
We have 5 panelists for the constitutional law issue that we'll talk about, and they will show how their issue impacts constitutional law. We'll begin with Dorian Coleman from Duke University.
Hi, everyone. Thank you so much. Just as cells are permeable so that infectious disease can move from cell to cell and spread within our bodies, so too our bodies are permeable so that disease can move from individual to individual and spread within our communities. In the face of infectious disease, it therefore makes sense to be communitarian, or at least to privilege our communitarian instincts. This means vaccinating to achieve herd immunity. This principle is deeply embedded in our most basic law, which authorizes the government to impose otherwise abhorrent restrictions on liberty, including mandatory vaccination in epidemic conditions. The court's 1905 decision in Jacobson versus Massachusetts remains the only case squarely to address the constitutionality of a local vaccine mandate. In Jacobson, the court rejected petitioner's argument that individuals have a substantive due process right to refuse their consent in circumstances where local authorities have concluded that universal vaccination is necessary to protect the public health. The court held that the city of Cambridge could require all healthy individuals to be vaccinated against smallpox. Since Jacobson, the court has decided only a handful of cases touching on vaccine mandates, none of which questioned its conclusion that liberty can be significantly ordered in the face of infectious disease. 2 of these, Prince versus Massachusetts in 1944 and South Bay United in 2020, suggested that the outcome would not be different in cases involving religious liberty rather than substantive due process claims. We're likely to see this assumption challenged in the context of any COVID vaccine mandates that don't include religious exceptions. Jacobson itself will be at issue, and it's certainly possible that the new composition of the court will affect its outcome. We got a hint of this over the summer as Justices Alito, Thomas, and Kavanaugh, writing in dissent in Calvary Chapel, Dayton Valley, cautioned that it is a mistake to take the language in Jacobson as the last word on what the Constitution allows public health officials to do during the COVID pandemic. When that challenge comes, Jacobson should nevertheless provide substantial guidance. As the court suggested at the end of that opinion, the question should be whether it would be easy enough to accommodate religious freedom claims without harming either the right of other individuals to be free from disease or the public interest in establishing the immunity of the herd. If it would be easy enough, on Jacobson's rationale that in a community committed to liberty for all, general terms should be so limited in their application as not to lead to injustice, oppression, or an absurd consequence, we should endeavor to do so. This is because state laws that allow for religious exceptions to vaccination requirements make sense for everyone. For religious people, exceptions are justified by their convictions. For everyone else, they're justified politically by our social compact and the harm principle. Freedom for others is the price we agree to pay in exchange for our own, and exceptions do no harm so long as still susceptible individuals can be protected and herd immunity can still be achieved. According to the operative communitarian principle, both religious exceptions and law reform that would restrict them are not only constitutional, but also on sound moral and political ground when they hew closely to these justifications.
Thank you. Our next panelist is Caroline Corbin from University of Miami College of Law.
The question I address today is whether it is constitutional to ban all mass gatherings above a certain size, including worship services during this pandemic. In particular, many churches have argued that forbidding large in-person services violates their free exercise clause rights. I want to suggest that such bans can be perfectly constitutional. The current constitutional rule is that neutral laws of general applicability do not violate the free exercise clause. A ban on all gatherings, secular and religious, easily meets this standard. A law is neutral if it does not target religion. A ban on all gatherings cannot be said to target religion. A law is generally applicable if it reaches all relevant conduct. In other words, a law won't be generally applicable if it only limited religious gatherings, but not analogous secular ones. A ban on all mass gatherings, again, does not have this problem. Now, many churches respond that state stay-at-home orders did target religious conduct, but not analogous secular conduct, by barring worship services, but allowing activities deemed essential, like shopping at a supermarket or a liquor store. Now, if these activities are not analogous, if gathering at a church and shopping for food and drink are not comparable, then the free exercise claim would fail. And they really are not comparable. At least when it comes to the reason why the bans were imposed, to limit the spread of the coronavirus, these activities are not comparable. The risks of transmission are greatest indoors, where people are interacting with each other for longer periods of time. Singing and speaking are also risk factors. While religious services have been the vector for multiple coronavirus outbreaks, and please check the list of sites I have in my original piece, such clusters have not been traced to people shopping at stores. The nature of the activities differ. First, the typical time spent in stores is much shorter. When people shop, they enter and leave as fast as they can. Services are extended affairs. Second, people in stores generally try to minimize their interactions as much as possible, a feat made easier by the ability to constantly move around. In contrast, the point of in-person religious services is to commune with one's fellow worshipers. Not surprisingly, the Johns Hopkins School of Public Health rated the contact intensity of shopping as low and that of places of worship as high. So based on science, these activities are just not comparable in terms of risk. And therefore, based on the law, mass battering bans are not unconstitutional. Thank you.
Thank you. Our next panelist is Cole Durham from BYU Law School.
Constitutional analysis of religious liberty problems during the COVID-19 pandemic would be enhanced if we paid more attention to protecting religious autonomy. After all, the most urgent issues are collective religious autonomy problems. The basic problem with traditional constitutional analysis is that the admittedly compelling state interest in public health always blocks sensitive consideration of COVID-related religious liberty claims. This is true under the deferential review called for by Employment Division versus Smith, but also under strict scrutiny that demands that state actions be justified by compelling interests that can be furthered in less restrictive way. To be sure, the concern for public health should often prevail, but after, not before, taking religious rights into account. Typical balancing tests are inadequate in the pandemic situation because as public health interests intensify, the significance of religion in people's lives also intensifies. It is no accident that in international law, religious freedom is non-derogable even in times of emergency. Indeed, it is often precisely in times of emergency that religion and religious freedom are most essential. Even arguably more sensitive equalitarian approaches that require comparison of religious practices with other social and business activities can fall short. These approaches deploy attractive equalitarian norms, but can still be outweighed by public health concerns. They allow arbitrariness in selection of comparators, and perhaps most problematic, the exclusive focus on equalitarian comparisons risks reducing religious liberty to a mere equality norm. In short, coronavirus poses not only a first-order crisis for public health, but also a second-order challenge to the sensitivity of the analytic tools we use to address the religious freedom issues involved. Focusing on religious autonomy supplements other balancing and equalitarian concerns. It underscores the importance of deferring within broad limits to judgments made within religious communities. This includes, but is more than, recognizing reasonable alternatives proposed as less restrictive alternatives. It requires respecting, though not necessarily accepting, the rights of the community to have its own distinctive beliefs. It requires good faith dialogue and a genuine commitment to finding reasonable ways to optimize the right of the community to live out its beliefs. Deference is central to respecting religious processes that are at the core of religious autonomy doctrine. What is called for is not unlimited, but respectful deference. Deference that not only treats groups equally, but with respect for their autonomy, dignity, and freedom.
Thank you. Our next panelist is Jeffrey Hammond from Faulkner.
Traditional public health regimes target disease-causing agents in the environment, like the novel coronavirus, and governors issue executive orders to limit the spread of the contagion. Traditional conceptions of public health derive their authority from the state's police powers over the people's health, safety, and welfare to limit the spread and lethality of virulent communicable diseases. Churches have been caught in the vice grip of the current public health orders. Most churches suspended their worship services to comply with governor's stay-at-home orders. Many churches limited the capacity of their worship services and tightly enforced physical distancing and mask wearing after the stay-at-home orders expired. Some churches went beyond the letter of public health orders and made caution the word of the day. My church, for example, has suspended congregational singing and passing the elements of communion. It is therefore confounding to see the governor of Nevada open Las Vegas's casinos at 50% capacity, representing thousands of patrons, while churches are limited to 50 total persons. The denial of Calvary Chapel's injunction application has exposed this. If the right to exercise religion is in fact America's first freedom, and if congregational worship is the heart of that free exercise, it is disheartening at best, portending mendacity and overt religious discrimination at worst, for governors not to respect churches' attempts to comply with public health norms, like social distancing and wearing face coverings, while seemingly ignoring those same norms when the state's economic viability is at stake. For as Justice Alito noted in his dissent, when gamblers are crowded around the craps table, social distancing will likely not be respected. The new public health aligns with so-called social determinants of health. Public health scholars have identified many non-disease factors that affect health and consequently are ripe for regulation, like wealth disparities and access to good food, safe housing, and competent education. Race-based discrimination and police abuses have also been identified as affecting the public's health and must be eradicated in order for all Americans to flourish. This new conception of public health was at play in the District of Columbia when Mayor Muriel Bowser allowed demonstrations against police brutalization of African Americans. Protesters did not consistently respect physical distancing standards. Many in the protests did not wear masks. At the same time, Mayor Bowser indefinitely stopped worship for all but the most modestly sized churches. The Capitol Hill Baptist Church has been completely sidelined by the mayor's order because its interpretation of the New Testament does not allow for virtual services or for serial gatherings of church members. Bowser has shrugged at her disparate treatment of protesters and church members, saying, First Amendment protests and large gatherings are not the same because in the United States of America, people can protest. The mayor is correct. People may protest their concerns about police brutality and racial injustices. Advocates of the new public health have applauded such protests, even while churches are deprived of their authority to worship, which compromises religious liberty in our American constitutional order.
Thank you. The final panelist for panel 1 is Samuel Levine from Touro Law Center.
For decades, the United States Supreme Court has declared that courts are precluded under what I refer to as the hands-off approach from evaluating and assessing the accuracy of the substantive religious claims regarding an individual's religious practices or beliefs. This approach has been subject to substantial criticism by myself and many who are participating in today's event. This issue arose, and some of the limitations on the court's approach were apparent in 3 cases or 3 categories of cases decided during the first 6 months of the coronavirus pandemic. First, Little Sisters of the Poor, the United States Supreme Court case, in which the court returned to the ACA litigation, to the contraceptive mandate. And once again, we see the same justices, Justice Alito and Justice Ginsburg, replaying some of the debates over the hands-off approach that had taken place in previous cases. Justice Alito insisting that courts must accept the substantial burden analysis as the religious claimants sincerely understand them, while Justice Ginsburg, similar to her approach in previous cases, expressed a willingness to make the statement to conclude that certain provisions do not impinge on the employer's religious beliefs, even when the religious claimants state that they do. In doing so, Justice Ginsburg again seemed to have expressed and demonstrated a willingness to defy basic aspects of the hands-off approach. A similar issue arose in the OLG case, likewise decided in July of this year, where the majority held in favor of the ministerial exception. In fact, the Supreme Court in Hosanna Tabor had unanimously adopted the ministerial exception. However, Justice Thomas, in the concurrence in OLG, expressed a highly deferential approach, concluding that the courts must defer to the good faith claims that a certain employee's position is ministerial within an organization, where Justice Sotomayor, this time dissenting, found that to be overly differential, and again, in a way that calls into question this hands-off approach, concluded that the court, or argued that the court, was all but abandoning judicial review. Finally, the cases that have been addressed by previous panelists regarding the religious gatherings. And without commenting on the conclusions that the other panelists have reached in terms of the merits of the case, I wanted to flag Judge Easterbrook's opinion for the Seventh Circuit, where he stated churches can feed the Spirit in other ways, and therefore the services did not have to be held in person, seeming to pass judgment as a judge on the religious claimants' beliefs, Whereas the Sixth Circuit, for example, made it very clear in their view, applying the deferential hands-off approach, that's exactly what federal courts are not to judge, how individuals comply with their own faith as they see it. So these cases demonstrate once again some of the applications and limitations and problems with the United States Supreme Court's hands-off approach.
Thank you. We'll now pass the baton to panel 2. Moderator is Justin Luttrell from Emory University.
Good morning. We have 6 panelists today discussing topics on law, religion, and culture. Our first panelist is Professor Robin Fretwell Wilson from the Institute of Government and Public Affairs and the University of Illinois College of Law.
Thank you, Justin. I'm going to share screen and maybe put some visuals to some of what we've been seeing. So thanks to Caroline Corbin and Professor Hammond for kicking that up for us. So in the beginning, homes, prisons, and meat packing plants. Now it's bars, strip clubs, casinos, and churches. Across the nation, churches have challenged the favored status of economic interests over religious ones, saying that they're regulated more harshly. The sense of being wrong has only escalated since mayors and governors have started to bring the economy back online. So consider Nevada's 50-person cap on worship services, which Professor Hammond talked about, and the very different approach they took to casinos. So you might remember this, Professor Hammond, from the complaint. It was attached, but this is, of course, Caesar's Palace. You can see nobody's socially distancing here. You know, these people are just engaged in revelry, and yet that got a pass from the Nevada governor that precipitated the lawsuit that Professor Hammond mentioned. Supreme Court summarily denied them a request for injunction. No surprise, given what they had done just before in South Bay United Pentecostal Church. But Thomas, Alito, and Cavedon channeled the outrage of religious persons. And I'll quote something different than Professor Hammond. They said, the Constitution guarantees the free exercise of religion. Nowhere does it say anything about the freedom to play craps or blackjack or any other thing. Now we see that pattern of favoring economic interests over religious ones in San Francisco. So this is the Archdiocese of San Francisco. It set up communion stations on its massive plaza outside that drew the fire of the mayor and more regulation, even though people can go to parks and congregate outside. Now they had to do this outside move because you can have only a single observer inside of the cavernous cathedral under San Francisco's present rules. And, you know, by contrast, to go to something that Caroline Corbin said, you can shop at your heart's delight at Nordstrom's, as the Archbishop noted, but you can also get a pedicure. And you can also get things like your hair done, as I've done recently. And those sort of sustain contact much in the same way that congregating for worship would. Now, my big picture point in the piece that I've contributed is that the incoherence of these regulations will breed disrespect for the law. In COVID-19 times, the government necessarily relies on these norms being self-executing. And there are simply not enough resources for the heavy hand of government to try to go around enforcing this on their own. Now that means we need people to buy in. And yet what we're seeing is that religious observers and religious gatherings recently, people have been very glib about these risks. So you'll remember that a small wedding in Maine became a super spreader in that state. There was a reception at a church afterwards, which blew out the top of the limit in the state for how many people could gather at a restaurant. And then few of the people there wore masks. That led approximately to 177 cases across the state in places as far-flung as a cabin in the woods near a lake. Now, to be sure, as Professor Hammond and others have said, churches can meet responsibly. It's absolutely true.
Professor Wilson, if you could, we're at 3 minutes, if you could wrap up.
Yep, thank you. I think they can meet responsibly, but the incoherence that people will not onboard the public health norm unless we give equal respect to worship and that they can see some coherence in these rules. Thank you.
Thank you very much. Our next presenter is Dr. Kathleen Brady, a McDonald Distinguished Fellow at the Center for the Study of Law and Religion at Emory University. It looks like we might be having some technical challenges. We can come back to Kathleen Brady.
Justin, that was my fault.
There you are.
Yeah, sorry. In our, thank you. And I said I'm not a doctor at the beginning there, but you didn't hear that. So in my written contributions to the program, I explore some of the constitutional and related implications of COVID-19 restrictions on religious worship. Litigation over COVID-19 restrictions began to pick up as states implemented reopening plans and religious groups started to challenge restrictions that they argue impermissibly favor secular activities over religious ones. So for example, in a case that reached the Supreme Court on an application for emergency injunctive relief, a rural Nevada church argued that the state violated the free exercise clause when it capped indoor religious worship services at 50 persons, but allowed casinos and other commercial businesses to operate at 50% of building capacity, regardless of the total number of people assembled. And we've heard about that case before. I argue that there are drawbacks to focusing on demands for equal treatment, including the fact that religious groups are often not really asking for being governed by the same rules as secular entities. For example, what the Nevada church really wanted was to maximize its ability to gather safely together in person, and its safety plan was in many respects more protective than rules applying to casinos. In my piece, I argue that another constitutional principle better captures what's at stake in these disputes. Government restrictions on in-person religious services interfere with one of the most fundamental aspects of religious practice, what for most American faiths is the lifeblood of the religious community. And as such, they should be governed by the principle of church autonomy that has begun to emerge from the Supreme Court's Religion Clause jurisprudence. This principle protects matters at the core or central mission of religious institutions from government intrusion. Of course, church autonomy can't be a principle without limits, and conflicts over COVID-19 restrictions test the limits of this freedom. These are exceptional circumstances where the state clearly has a compelling interest in protecting public health. However, these circumstances don't give governments unbounded power. The principle of church autonomy requires government officials to carefully tailor their rules to maximize the ability of religious congregations to meet safely together. The principle of church autonomy also requires more. Church and state often interact, but when they do, the independence of each must be recognized and respected. In the context of COVID-19, this means that religious leaders and government officials must work together to develop the rules that apply to religious worship. Communication and attentive and timely consideration of input and proposals are essential. Effective partnerships also build trust and reduce the likelihood that religious congregations will violate safety rules or insist upon engaging in risky behaviors, something that has been increasing as the pandemic drags on. If religious adherents believe that their governments recognize the urgency of their concerns and are willing to work with them to reduce the effect of the virus on their faith lives, all of our communities will be safer and more stable. Thanks.
Thank you, Kathleen. Our next speaker is Professor Angela Carmela of Seton Hall University School of Law.
Thank you, Justin. I'm going to shift gears to a different idea, commemorating those who've died. In our times of national grief, there's so much to mourn. The commemoration of lives lost to COVID and to racial injustice has already begun. Communities have created spontaneous memorials, like yards filled with thousands of flags. They've created street art, painted murals. They've projected photos onto sides of buildings. We will continue to honor the dead in more permanent ways with services and monuments, often in partnership with government at all levels. My question today is, how will the Establishment Clause shape this expression of civic sorrow, if at all? Now, we can show our collective grief using religious or non-religious language and symbols. And regardless of the choice, honoring the dead is a sacred civic activity. The September 11th prayer service at Yankee Stadium was religious, but the Vietnam Memorial is not. And yet it is a holy site, even without the markings of faith. The line between religious and non-religious is often indeterminate, especially when it involves remembrance. Now, as to the Establishment Clause, the court's interpretation is now more relaxed than ever. It accepts religious language and images in government spaces. Even intensely religious words and symbols can carry civic meaning. They are particular means to universal ends, says the court. But is this just the court preserving history and tradition, elevating majoritarian faiths? Is this simply another way to exclude disfavored, underrepresented groups? The court itself says no. It insists that inclusivity and non-discrimination are necessary values. Now, in normal times, I would be apprehensive. Mixing government and religion can degrade both. But these are not normal times. A relaxed establishment jurisprudence may be a good thing, especially given the massive tragedy at hand and the indeterminacy of the line between religious and non-religious. We have before us the necessary cultural task of memorializing national sorrow and the task of crafting images for national atonement and reconciliation. The grieving families and anguished protesters are creating sacred symbols of their own. All communities, especially underrepresented ones, need the freedom to express themselves in many different voices.
Thank you, Professor. Our next presenter is Daniel Bennett of John Brown University, who will be speaking on behalf of himself and Professor Andrew Lewis of the University of Cincinnati.
Yeah, thanks very much. I'll shift gears yet again and talk about our focus on the Christian legal movement and interest groups engaging in advocacy on these issues. So as we've been talking about this morning, early on in the pandemic, many states required modifications to church services to reduce the transmission of the virus. Most churches ended up transitioning online or to outdoor services where allowed. Others fought the regulations hard. Calling basically any regulation unconstitutionally burdensome on their First Amendment rights. Several groups in the Christian legal movement joined in, using these cases to show their support for their conception of religious freedom and portray the restrictions as evidence of animus against religious activity. So Professor Lewis and I were curious about how these groups litigated these kinds of cases in public and in the courtroom. Many organizations tended to emphasize hyperbolic rhetoric in their public press releases and their legal filings, essentially echoing the political rhetoric of elites like President Trump and suggesting that the pandemic is just a vehicle to turn up the heat on churches and religious communities in America. So for example, First Liberty Institute highlighted, quote, the real agenda of our opponents, to keep our churches shut down indefinitely and attack religious freedom in America. While the American Center for Law and Justice accused, quote, extremists on the left are using the coronavirus as an excuse to attack Christians. So Professor Lewis and I are concerned that this tendency has the potential to backfire for a couple of reasons. So first, it could muddy the water when it comes to cases that have potentially more merit, such as the ongoing cases in Nevada and DC, as a few of our presenters have mentioned. The public may not take those more legitimate claims seriously after being presented with so many other possible cases. And related to this, the polarization of religious freedom could destabilize support for religious freedom broadly, which of course could have negative effects on the very groups making these polarizing arguments. And so ultimately we close our essay by writing, churches and Christian legal groups may win smaller battles and garner immediate political support by fighting tooth and nail against even the most minute public health regulation. But this strategy does little to win the larger war for expanded religious freedom protections for all. Thank you.
Thank you, Professor Bennett. Our next speaker is Isabel Park, a project assistant at Sidley Austin LLP.
So as part of the panel on law, religion, and culture, I wanted to raise a discussion about how the pandemic will have left a permanent mark on our worldviews, which requires acknowledging that the coronavirus pandemic is not only a medical crisis, but also a moral and a spiritual one. And so I think it's important first to establish this concept of worldview. And this worldview it's a philosophical and cognitive framework that orients not only the universe, but also our relation to it. And so our worldviews can be rooted in theological doctrine, as well as in scientific theories, values, emotions, and our experiences. And so our current situation with the pandemic forces us to confront and to synthesize ideas that typically don't go together in our normal, ordinary lives, like mind and body and life and death, for example. And the underlying tension that a lot of us struggle with of balancing logic and reason with our emotions and experiences has become a lot more prominent in the face of crisis. So I think it makes sense that we feel the need to alter our worldviews, at least partly because a disturbed and incohesive worldview is highly unsatisfying, particularly when our worldviews prior to the pandemic felt so stable and comprehensive. What I think is happening to many of us in unique ways is that we're rethinking how well our worldviews can accommodate the new realities of our pandemic-ridden lives. And this can affect both religious and non-religious people in different ways. So for example, Christians might struggle with understanding, how a supposedly perfect God could allow suffering and pain, and how such a God could at the same time have an ultimately good purpose. On the flip side, for non-religious people, religion might appear to provide more accessible and emotionally comforting answers than medicine and science might. And so the upshot of the coronavirus's impact on our worldviews is that the Christian church has a greater potential to provide a spiritual framework to people that might be unusually open-minded to such considerations in light of the pandemic. And an important part of this consideration, an important part of this is considering how remote religious services highlight the definition and essence of church, and what this might reveal about the church's role and how it should fulfill that role in our current situation and beyond. Thank you.
Thank you very much. Our final speaker on this panel today is Joanna Smith, who is a PhD candidate in the Department of Religious Studies at UNC Chapel Hill.
Thanks, Justin, and thank you so much to all of our other panelists as well. So in my contribution, I turn to an ostensibly secular site to tease out the ways in which the pandemic has revealed and magnified the status of American slaughterhouses as spaces set apart. And specifically, I argue that the pandemic has been marked both by a public embrace of slaughterhouse workers as heroes and patriots, and simultaneously by an ongoing disavowal of the violence that takes place within slaughterhouse walls, violence that very much includes now the needless and preventable spread of coronavirus. As we've seen this past spring and summer, slaughterhouses are potent symbols of American industrial ascendancy, of productivity, of profitability, of abundance. And public rhetoric around meat production during the pandemic has been absolutely saturated with nationalistic and even a sort of militaristic pride that has deep historical roots. But those who have been observing closely over the past 6 months have also seen the extent to which slaughterhouses have been treated as liminal spaces, spaces where, unfortunately, we may need to just accept that the virus is going to spread. This past spring, the federal government instituted changes that allowed plants not just to stay open during outbreaks, but also to opt out of health guidelines that would interrupt productivity. As a result of this, over 200 workers have died and tens of thousands have gotten sick. And the sad truth is that this is not a surprise. This is simply the slaughterhouse churning on exactly as it was designed to. Because the truth is that over the course of the last 2 centuries, the slaughterhouse has been carefully developed to function as a site of legal exception, within which violence against both animals and workers, many of whom are immigrants and people of color, is hidden from the public's gaze while being rendered licit. So like so many spaces that are set apart from public life, the slaughterhouse has proven its ability to both attract and to repel. This is nothing new. But what is new right now is how visible this dynamic has become. Outbreaks at plants have rendered the messy work of killing and the exploitation that allows it to churn on much more visible than it's been in decades. So this is a moment at which public gaze has the potential to disrupt the meat industry as we know it. There is nothing inevitable about how slaughterhouses have evolved to their current status as sites of legal and indeed cultural exception, and there's nothing inevitable about their trajectory in the months and years to come. Thank you.
Thank you very much, and thank you to all the panelists on the Law, Religion, and Culture panel. We move next to the panel on legal and religious practices with Professor Michael Moreland moderating.
Thank you, Justin. And our first speaker will be Patrick Hornbeck from the Theology Department at Fordham University on revival statutes, clergy sexual abuse, and COVID-19.
Thanks, Michael. In the months before the pandemic struck, Google searches on the terms religion and epidemic tended to produce two different kinds of stories. One about the opioid crisis, the other about sexual abuse within religious institutions. And in both the Catholic and Baptist traditions, commentators characterize the patterns of abuse and concealment as epidemic. Many state legislatures responded by reforming statutes of limitations, 9 in 2019, creating revival windows during which victim survivors could pursue expired claims against abusers and their employers. And legislators in enacting such laws weighed the competing imperatives of compensation, deterrence, finality, and judicial autonomy. But victims and their advocates have reported that the pandemic has hampered their ability to initiate litigation. And even some Vatican officials have agreed that abuse has moved out of the center of attention during COVID. 3 US jurisdictions' revival windows have been scheduled to close since the coronavirus reached the United States. Montana's biennial legislature was out of session, and so their window closed without debate. Hawaii considered, but ultimately didn't adopt further limitations reform. But in contrast, New York extended its revival window by an entire year. In my blog post, I described the twists and turns that produced each of these different outcomes. In the next several months, windows are slated to close in 3 more jurisdictions: Arizona, Washington, D.C., and New Jersey. And so I ask, what lessons should these states learn from the ones that have come before? First, public and media attention to sexual abuse within religious communities and other human families have dropped sharply in the pandemic. Absent conscious efforts to focus on the topic, revival windows will likely expire as scheduled. Would-be plaintiffs stand to lose entirely when windows are shut, and yet defendants too have an interest in being able to rest confident that the time for claims to be brought has passed. So legislators need to consider carefully the length of any extensions, timing them to compensate for but not exceed delays in the pandemic. But it may not be the duration of a revival window that will most circumscribe plaintiffs' ability to obtain recompense. As we know, many religious institutions and secular nonprofits have felt the economic consequences of the pandemic acutely, and the intersection of COVID with limitations reform has been particularly damaging for the Roman Catholic Church. Even yesterday, one of the country's largest and best resourced dioceses filed a Chapter 11 petition. So the future remains uncertain. The best course of action for historical sexual abuse plaintiffs and those who counsel them is to file claims at the earliest opportunity, as there's no guarantee of political will to extend these expiring windows, nor any assurance that organizations will have the funds to satisfy judgments. So last, for those abused by spiritual leaders and feeling betrayed by institutions, it may actually be an unexpected pandemic that denies them justice. Thank you.
Thank you, Patrick. And now Dwight Newman from the University of Saskatchewan will speak on when the state tells you how to run your church service, analyzing coronavirus guidance documents on religious services.
Good morning, and thank you for the opportunity to be part of this event. My contribution stems from one simple question. Is the coronavirus pandemic setting a precedent for the government to tell churches how to run their worship services? The question arises from guidance documents on worship services issued by state governments during the recent months, particularly of reopening. And being from Canada, I'll refer to similar documents from Canadian provincial governments as well. Obviously, there are compelling health reasons why things are different right now. But even in the context of the pandemic, different governments have made very different choices as to how much they interfere with religious entities. That raises questions on to what degree the interference is necessary and justified versus simply generating a concerning precedent of state overreach. My contribution proceeds based on examining the different guidance documents. I identify some of the more striking interferences in religious services, and I contrast those with more respectful approaches. In terms of greater interference through mandatory provisions, I point to jurisdictions like California, Washington State, and New York State that have regulated, or in California's case, even banned singing. This obviously constrains an important part of many liturgical traditions and what is for many an important means of emotional and whole body engagement in worship. I point to those that impose requirements to maintain registries of attendance at services, as in the District of Columbia and British Columbia. And I point as well to several jurisdictions that impose mandatory rules on sacramental objects, such as the communion cup. I don't doubt that all of these rules have health-related bases, but within principles of separation of church and state and religious autonomy, it's still problematic for the government, even inadvertently, to have its regulatory muzzle on the liturgy or its regulatory hands on the communion cup. There are alternatives. A number of states issued guidance documents, but made clear that these were to provide helpful suggestions and formed part of a dialogue with religious entities. That kind of respect for the freedom of the church, or more broadly, the sphere of jurisdiction of religious entities apart from the state, can work with a balanced and constructive approach to achieve health goals while respecting church-state separation and religious autonomy. The fact that a number of jurisdictions have failed to go that route and simply imposed requirements raises a concerning precedent from the coronavirus pandemic for future interference.
Thank you. And next we will hear from Daniela Tarantino, who is at the University of Genoa and will speak on the Drive Confession, the Care of Souls at the Time of the Pandemic.
Thank you very much for giving the opportunity to present the current state of my research in this important webinar. The Catholic Church has worked to find ways and times to answer to the COVID-19 emergency. In this context, the sacrament of reconciliation is of central importance. According to the norm of the Codex Iuris Canonici, the ordinary way of celebration of this sacrament remains the individual confession, but it is recalled that a collective absolution can be given where the imminent danger of death or a serious need occur. Episcopal conferences around the world have promoted, or at least not hindered, the search for alternative forms of carrying out to perform to celebrate the confession. This is the case of the Drive Confession, an idea conceived in Maryland, where Father Scott Holmer, a priest of the Catholic Church in the city of Bowie, began to confess the penitents faithful through the windows of their cars, parked in a church courtyard. Several priests from Austin in Texas have invited parishioners to a penitential in car in the parish parking. From the United States, the idea spread to Europe, arrived first in Poland and then in France. So the on-the-road confession is certainly an unprecedented method of administering the sacrament, which, however, maintains the simultaneous physical presence of both the penitent and the confessor. More daring is the method suggested by Peruvian Bishop Reinaldo Nunn, who authorized priests to celebrate confessions by telephone, emphasizing on reconciliation as care of the soul, and the priest as medicus animarum. In Bergamo, one of the cities Italian most affected by COVID, the priest Luciano Locatelli administered the sacrament of reconciliation through WhatsApp, in the belief that Jesus, at the time, would have done the same thing. The use of technological tools appears impracticable given the absolute inviolability of the confessional seal. But the violation of the seal operates only in the case of spreading or disclosure of the matter object of the sacrament. Absolute inviolability can be guaranteed by the awareness of both the confessor and the penitent of the sacredness of the act, which does not depend on the place where it happens, neither by the way it takes place. Moreover, during the pandemic, the use of modern technologies has supported the diffusion of sacramental grace on several occasions. With reference to the modalities of administration of the confession, the Church should manifest herself not only as an institution, but also as freedom of the spirit. Thank you very much for your attention.
Thank you. And now we will hear from Alejandro Gonzalez Varus, Professor of Public Law at the University of Zaragoza in Spain, on law, religion, and coronavirus between the United States and the European Union. Alejandro, I think you're muted.
Sorry. Yes, good evening, everybody from Spain. Sorry for this audio. Well, it's truly an honor to deliver this speech in this webinar, and thank you to organizers. I'll try to explain the main legal measures and reactions with regard to religious freedom and COVID in the European Union and the USA. More than half of the European Union's member states proclaimed the state of emergency at the beginning of the coronavirus epoch. All member states have prohibited public gatherings, including religious ones, in different ways, though. In the American case, there have also been some differences between states that have permitted religious assemblies, even with restrictions, and the states that have banned them. Then, in the development of lifting COVID containment measures, European Union rules haven't spoken at any time about religious celebrations, but Council of Europe texts have made specific references to religious freedom indeed. The most of religious denominations have cancelled their public worship activities, both in the European member states and in the United States. And they, the religious denominations, I mean, have deployed a cooperative attitude with the civil authorities. In any case, this behavior has not prevented them from showing their complaints about the limits eventually imposed on religious freedom. In the European frame, the most rooted denominations, such as Christian churches, have claimed that the reopening of churches must be implemented in dialogue with ecclesiastical authorities. Nevertheless, these situations have usually not reached the courts in European countries, and there isn't case law in the courts of the European Union or in the European Court on Human Rights. This is a difference from the situation in the USA, where the banning of religious gatherings has raised more often litigation in US courts, even in the Supreme Court. Finally, at least in Europe, religious minorities such as Muslims or Jews have had other worries. For them, it has been disturbing the rise of hate speech, racism, stereotyping of minorities, and misinformation. They have also been alarmed by the spreading of blaming the creation and propagation of the virus on them. Thanks again.
Thank you. Matthew Cavedon, one of the other panelists, was detained in a court hearing, so I will turn it over to Mark Movsesian from St. John's University for the panel on religious organizations.
Very good. Thank you, Michael. Thanks to the panelists. Our first speaker is Professor Marianne Case from the University of Chicago.
So I will be speaking about COVID and egalitarian Catholic women's movements. And I'm grateful to the organizers for stretching a few points and including me. This is a symposium on law, religion, and the coronavirus in the United States. And because I am talking about the Catholic Church, I am not focused on the United States, but on the Universal Church. I'm glad to see I was not alone in this. And the law I'm focused on is also not US law, but canon law. And I'm motivated to do this because coronavirus comes at a time in egalitarian women's movements within the church where they are increasingly turning to rights claims to formulate what they have long wanted. They're demanding equal voting rights, they're demanding equal access to the offices, and of the church. So I begin my blog post with Pope Francis's injunction in his March 27th Urbi et Orbi message that the coronavirus is, quote, not the time of God's judgment, but of our judgment, a time to choose what matters and what passes away, a time to separate what is necessary from what is not. And then I use the rest of the post to examine what, on the one hand, the women, and on the other hand, the clergy and the institutional church have chosen to accent as necessary. I structure my post around two video images. One is of Pope Francis in the aforementioned Urbi et Orbi message, standing alone in St. Peter's Square, flanked by an icon and a crucifix, and only a handful of male clergy, with even the voices singing behind him being only of men, reminding us that the canon law for a long time prohibited women's singing in church. And I contrast that with a series of Catholic women's egalitarian Zoom sessions that I personally experienced as an observer over the course of COVID. And the image to contrast with Pope Francis alone in the fenced off St. Peter's Square is an image very familiar to all of us now of hundreds of tiny little Zoom checkerboard faces of women and men of all ages, and conditions from all around the world gathered together to celebrate what amounts to an alternate liturgical year that focuses on the classic moments of the Catholic liturgical year, like Easter and Pentecost, but focuses on them with a special eye toward women's contributions to these events and to salvation history. And then a series of Zoom events focused on women's feast days, the newly instituted Feast of St. Mary Magdalene, for example, or the Feast of...
Sorry, Professor Case, your time is up. So you just one more sentence, please.
And I then look at the way in which what the church has announced in the past year with respect to baptism needing to be I rather than we, and the title of the encyclical Fratelli Tutti, decreasing the likelihood that people will come back once the churches are open.
Great, thank you very much. Sorry, Professor Case. The next speaker is Professor Christopher Lund from Wayne State University.
So when the government imposes quarantine orders for public safety, it shuts some things down while leaving other things open. And in that world, how should religious organizations be treated? One response is that they should be treated equally, and it's a good response, but equality is not self-executing, and the deeper you go into these quarantine orders, the more that becomes clear. In my time, I want to convince you of two things. First, quarantine schemes require the government to make judgments about the value of religious exercise in uncomfortable ways. And second, quarantine schemes flatten religious difference in similarly uncomfortable ways. My first point, quarantine schemes require the government to make decisions about how much religious services are worth. Forget religious organizations for a second. Just consider non-religious ones. If you were in charge of deciding what things should open and when, you would naturally take into account the value of the thing in question. Grocery stores and hospitals are too important to close. Daycares open before other sites with comparable transmission risk because we know working parents need them. Determinations about when different things should reopen don't merely involve questions of fact, what's the amount of risk, but necessarily involve questions of value. Is it worth the amount of risk? California had a 5-stage reopening plan with different things opening at different times. Where do you fit religious organizations in? We must listen to the who can tell us about comparative transmission risk, but we also need someone to tell us about the comparative value of those things. And that creates the issue. You know, usually people make their own decisions about the value of religion. Some people might find religion valuable or invaluable or worthless, but they make their own decisions and the government usually doesn't. But now we're affecting each other more than before, and we have to make collective, that is governmental decisions about the value of religion. And it has to be this way, right? We have to classify organizations by type. If we only had generally applicable rules like indoor masks or 6 feet apart or buildings at 50% capacity, we wouldn't be able to prefer organizations of certain types like grocery stores and hospitals and daycares. So we have to classify organizations by type, but that requires judgments by the government about religion's worth. My second point, quarantine schemes flatten religious difference in uncomfortable ways. Look into the reasons governors gave for categorizing religious organizations where they did. Or look in the arguments in the litigated cases. Look into their judgments of transmission risk. You see a lot of talk about singing, for example. There's a lot of risk with singing. And if you looked at the governor's orders and you looked at the cases, that's your image of what happens at a religious service. But of course, not all faiths sing during religious worship services. Some faiths don't really even have worship services. We're figuring out what restrictions to impose on religious services generally, using some conception of what usually happens at a religious service, but that conception will be shaped by the practice of dominant majority faiths. To put it bluntly, these quarantine orders have regulated all faiths, as if all religious meetings look like Sunday morning Christian worship services. That's my time. Thanks for having me.
That is exactly your time. Thank you very much. The next speaker is Professor Adelaide Madera from the University of Messina.
Thank you. This is about the impact of coronavirus on public funding of religious organizations. Since Everson versus Board of Education, access to public funding for religious organizations has been a controversial issue and fiercely litigated. During the pandemic crisis lockdown, the enactment of the CARE Act that established the Paycheck Protection Program raised new challenges for religious charities. Many concerns arose as to whether religious nonprofits were eligible for government funding, whether accepting loans implied that religious organizations were federal contractors, to what extent access to public funding could affect their religious identity. Over the last 30 years, the Supreme Court embraced a trend of progressive erosion of the principle of separation, promoting an equal treatment of religious and secular organizations in relation to access to public funding. The judiciary overexpanded the protection of religious exercise, as well as reducing the Establishment Clause to reinforce the goal of the Free Exercise Clause. So a religious organization cannot be discriminated against compared to its secular counterparts because of its religious status. The law is neutral, generally applicable, and provides support to all organizations that qualify for 501c3 status. And under the emergency rules, religious organizations receive neutral, non-distinctive treatment under COVID-19 restrictions and are considered on a par with secular organizations for loans. The pandemic has showed us not only the need for a cooperative synergy between all the parts of society to face the emergency, public, private, secular, religious, but also that there cannot a hierarchical order of constitutional protected rights. Sensitive balance have to be reached. Nevertheless, the maintaining the values of pluralism, openness, and democracy implies mutual respect of diversity and equal expressive freedom for all. At the same time, not all the claims that self-qualify as religious can be satisfied. And finally, I guess that opportunity offered by the loans implies a recognition of the religious organization's valuable contribution to the achievement of shared goals, without forcing them to renounce spreading the religious message. In this way, all social actors are encouraged to fully contribute to promoting a model of pluralism that leads to a fully inclusive society. Thank you.
Thank you very much. Our next speaker is Zachary Pullman, who's the editor-in-chief of the Notre Dame Law Review.
Thank you. My blog post starts with the premise that regular in-person gatherings at churches and other houses of worship were suddenly stopped in mid-March, and that now, even though we're 6 months out from the initial outbreak and churches have begun to reopen, religious attendees are attending religious services in much lower numbers than they were before the pandemic. My blog post explores some of the implications of the church shutdown and gradual reopening from both a legal and religious perspective. From a legal perspective, I take on a very narrow question, namely, how does the shutdown affect a church's eligibility for tax benefit purposes? Under the tax code, churches receive special tax benefits beyond those received by other 501c3s, such that it becomes necessary to define what counts as a church. In a forthcoming article, Lloyd Meyer and I argue that churches should be defined by what's called a congregational approach, a test currently used in a few federal circuits. We define the congregational approach as the regular in-person gathering of individuals to engage in worship and other communal religious activities. Now, there's obviously a lot going on in that definition, but the coronavirus raises an interesting question. What happens to the congregational approach during a pandemic when in-person church gatherings are not possible? I argue that so long as a community of religious believers intends to hold regular in-person religious gatherings, transitory crises that make such gatherings impossible should not cause a church to lose its status as a church for tax purposes. And the test for measuring this intent is easy enough. If the congregation met regularly before the transitory crisis, we'll presume it will continue to do so once the crisis passes. Turning then to a religious perspective, I ask what effect the last 6 months might have on how churchgoers themselves conceive of what it means to be a church. Again, my focus is pretty narrow. I suspect it's possible that as religious services were moved from churches to living rooms, aspects of church life previously thought inviolable, things like liturgy and ritual and community, may seem less important. My blog post focuses on revitalizing the important role that community in particular should play in what it means to be a church. In my own Catholic tradition, a church has never been understood to be merely a physical building. Rather, as Jesus tells us, where 2 or 3 are gathered together in my name, there I am in the midst of them. But even beyond the strictly theological, churches and religious congregations of all faiths can provide a source of community unparalleled by non-religious groups. I'm hopeful that given the stress and despair the last 6 months have caused many, if ever there was a time for a resurgence in church attendance and a culture that truly values religion and religious liberty, this is it. At least I so pray. Thanks.
Thank you very much to all the speakers. I'm now going to pass it off to the next panel and the next moderator, Professor Stephanie Barkley from Notre Dame.
Thank you. So our panel is focusing on theological implications and some reflections. We'll start with the first panelist, Paul Marshall, and his blog post is about political theology and church restrictions.
Yep. I should mention at the outset that I'm not a lawyer, but I'm involved with the Religious Freedom Institute's project on institutional religious freedom, and that has drawn me into this subject. So I hope you will forgive me. Several churches are resisting government restrictions on in-person worship and offering theological grounds. Notably, John MacArthur, an influential conservative pastor, has argued that no biblical text grants civil rulers jurisdiction over the church, or again, that God has not granted civic rulers authority over the doctrine, practice, or polity of the church. But these are two arguments. One argument frames the issue in jurisdictional terms. The other is a separationist argument. Similar things are being offered by many churches. What is striking here that conservative churches, which have usually been very strongly Paul needs to unmute.
Paul, you seem to have muted yourself.
Sorry, I'm not sure what I missed, so I'll just carry on. Galasius argues in his famous letter to Anastasius, if the ministers of religion obey your supremacy in matters affecting the public order, with what readiness should you not yield to them in the sacred mysteries of religion? Galasius argues that church and state interact according to their own specific mission and jurisdiction. Hence, these are not his arguments, churches obey zoning regulations and fire regulations. A minister could even be arrested for a sermon if the sermon was treasonous or incited a riot. In turn, churches impose authority over politicians. They may deny them communion if they believe they're in violation of church teachings. These are two authorities over each other. This is typical of most of our relations in society. So, for example, a professor has authority to grade a student. If that student happens to be a policeman, that policeman has the authority to give the professor a speeding ticket. Each has a specific authority over the other. They must submit to each other in particular ways and exert authority over others in particular ways. I think a misunderstanding of these issues have led some churches and indeed some states to miscast the theological background involved. Thank you.
We'll go to our next panelist now, and that is Terry Montig with Redeeming Justice. And apologies if I said that last name wrong.
No problem. It's good to be here with you. I contributed to the forum a theological reflection on redeeming justice, a term I've coined. In Christian tradition, humanity's fall diminished human dignity and brought into human existence a kind of death that manifested as alienating separations, disrupting and impairing communion with God, community with others, and comity with the natural world. God responded by intervening to redeem, to bring back or restore the entirety of human life and all creation. Through Christ's willing death and resurrection, God righteously restores and fulfills human being in and for community. Otherwise, unrighteous humanity tends towards a senseless existence that leaves the church groaning under the burden of faithless mortality, humanity groaning under the burden of heartless society, and nature groaning under the burden of a careless and sometimes ruthless humanity. The present global pandemic and protest movements have challenged our mortality and the basis, boundaries, and strength of our community. As the world experiences concurrent personal, spiritual, social, and ecological unrest, this unrest can be understood as protest, and together as concerted protest against the deadening effects of human activity on human mortality, in human relations, and for the divinely ordained habitat and scene of human existence. In the logic of redeeming justice, the pandemic and justice movements cohere and redemptively work together for good to advance and restore right relations and just action in the church, in society, in creation. Distinctively, redeeming justice remembers the Redeemer God as prophet who calls God's people and the nations back to God and to faithfulness, as priest who mediates peace and facilitates justice, as king who reigns righteously and balances the life interests of all within the creation. Redeeming justice integrally relates legal, social, and environmental justice with moral justice. It reminds us that the world is a holistic unity and hastens new ways to fulfill the promise and potentials of justice according to the full dimensions and demands of community. My post outlines what it means and ways to redeem justice in the church, in society, and for the natural world. At this seminal moment, our ability to constructively participate in redeeming justice depends on our response to protest. Will we, in frustration, disparage and dismiss protest as mere random occurrences of disease, civil disobedience, and desolations? Or, in the logic and spirit of redeeming justice, will we, in hope, understand and let this protest spur us to embody and enact a more faithful, equitable, renewed community? Thank you.
Thank you, Terry. Our next panelist is Brett Sharps, speaking about the COVID crisis as the crisis of trust.
Thank you, Professor Barclay. Hello, everyone. Thank you for joining us for this blog webinar. Ask a family therapist what is most likely to destroy a marriage, or a business consultant what is most likely to damage a successful enterprise, or a political scientist what will sabotage a nation, and you are likely to get the same answer: trust, or to put it negatively, the end of trust. When we stop trusting each other or the institutions we inhabit, it's difficult to imagine what else we might do right that will compensate for the harm done by the eradication of trust. Thus, it is through the prism of trust that I have been thinking about the coronavirus crisis. Perhaps the most disheartening aspect of the COVID crisis in the United States has been its politicization. attitude towards basic preventative measures such as social distancing and wearing masks vary dramatically depending upon whether people identify as Republican or Democrat. For churches and church leaders, trust has never been more important than it is right now. For religious leaders, one of the most important benchmarks for decision-making during this crisis is how to engender rather than undermine trust. One of the things I have found interesting and heartening is how innovative, creative, responsive, and responsible most religious leaders and communities have been. Many, though not all, and not the ones we tend to hear about in the news, have acted in ways that generate trust at a time when the need for trust is at a premium. With a presidential election just 1 month away, we are right to be worried about whether we can trust something as basic as the integrity of our electoral system. There is real and widespread fear that the outcome of the presidential election in either direction will result in the disappointed side reacting with protests that become violent. The number of people on the left as well as the right who seem willing or inclined to burn it all down seems distressingly high. In my lifetime, I've never been more concerned that the middle will not hold, that W.B. Yeats's vision of a time when, quote, the best lack all conviction while the worst are full of passionate intensity is upon us. Interestingly, Yeats wrote those words in the aftermath of the 1918-19 flu epidemic, shortly after his wife, who was pregnant, came close to dying from the influenza. Religious people, religious leaders, and religious institutions have an important role to play. We should each look to the belief systems we hold dear, to their most profound doctrines and convictions, as we seek guidance on how to react in times of tremendous stress and adversity. Most of our religious traditions have resources in doctrine and practice that can help us navigate this crisis. All of us should ask ourselves if we are behaving in ways that reflect the best of our faith traditions and will generate and be deserving of trust in ourselves, in each other, and in our most cherished institutions. Thank you for being a part of our webinar today.
Thank you. We'll go to our next panelist, who is Anton Sorkin, with discussing Christian public engagement in a time of crisis.
Okay, thank you for the introduction. Thank you for the host for allowing me to take part in this important conversation. So my submission was essentially based on my research and observations for the last 4 years concerning the state of the Christian church in America, in particular, how the church has responded to various trials and how the optics of its discontent has played a role in shaping its public image. And thinking about the public engagement of the church during this crisis, I thought about the interaction between 3 main issues. The first one is the autonomy of the church, obviously subject to the laws of the state, but also mostly independent in its ability to shape its own identity. One of the markers is corporate worship and the theology surrounding in-person services as a defining feature of Christianity, what Kathleen Brady earlier referred to as their lifeblood. The recent lawsuit filed by Mark Dever's church in DC has done a good job, for example, showing how the bans of in-person services violate their theological convictions surrounding the physical gatherings of believers, discussed in various sources like the letter to the Hebrews and demonstrated in the book of Acts. The second thing is the public health concerns and the need to make life-altering decisions that carries widespread support. Now, this widespread support means that non-compliance will have its repercussions, not only legally, but also in the court of public opinion. And so decisions need to be made to carry out the church's spiritual mission without exacerbating its crisis of legitimacy through needless disobedience. And the third is the issue of how the church can embrace this moment through a fruitful public engagement, mindful of its mission to serve the broader public, their need to retain the marks of distinction, and how this all plays towards the development of a social capital. In essence, the question is how to best share, to quote Reinhold Niebuhr, in the burdens of immediate situations. So to this end, I discussed these issues and offer my reparative thesis for public engagement. My final one being that the church needs to continue to pray as its ministers to their communities in this time of great uncertainty.
Thank you. We'll now go to our final panelist of the day. Last but not least, George Walters Slayan discusses Through the Eyes of James Cone, COVID-19, police brutality, and the Black Church.
Thank you very much. This presentation is a critical analysis of COVID-19 police brutality and the Black Church through an interpretive lens of the works of James Cone. It defines the prevailing climate of police brutality in the United States as an intersectional experience for the Black person. The experience is theological, political, economic, and socio-culturally embodied as it considers the historic amnesia of American law enforcement towards Black humanity. COVID-19, a disproportionate death of Black folks, and intentional acts of police brutality against living Black reflect the historic angst of the Black experience. Amid COVID-19 and police brutality, the Black Church exists as a standard of civility, justice, and refuge. Like the days of slavery and the underground church, the Black Church remains a center of refuge in its tries to provide an anchor to the weary victims of this American dilemma. For Cone, the experience dates to slavery, especially the post-slavery era of white America's public lynching of Black people from 1880 to 1968. About Cone, he is a theologian, was born in Arkansas in 1938, which was then a lynching state. The only place of upliftment and sanity for Cone and his family was the Black Church. This presentation explores Cone's analysis of what he refers to as the American Holocaust and its continuity into the 21st century. For Cone, the American Holocaust displays white supremacy as the foundational psychic against Black humanity. This presentation will cover four descriptive areas in Cone's analysis. One, Black lynching in the US is Black crucifixion. In the cross and the lynching tree, Cone provides a socio-theological and intersectional analysis of the lynching tree and the cross. For Cone, God transformed lynched Black bodies into the re-crucified body of Christ. Two, police brutality is post-modern Black lynching. George Floyd, Michael Ramos, Breonna Taylor, Eric Garner, the list goes on. According to Cone, the lynching of Black America is taking place in the criminal justice system. That is why the term legal lynching is still relevant today. One can lynch a person without a rope or a tree. Thirdly, US COVID-19 is 21st century Black health crucifixion. In God of the Oppressed, Cone's goal is to describe and interpret the Black experience as living Black in the United States. The Black experience denotes multiple experiences, which include disparities against Blacks in the US healthcare system and the use of Black bodies as guinea pigs. Finally, God is Black as the crucified Black Church. According to Cone, the Black Church was born in slavery. It came out of the brutalizing reality of white power in protest to protect the humanity of Black people as one institution untouched by white power. Unlike the white church, he writes, its reality stemmed from the eschatological recognition that freedom and equality are at the essence of humanity, and thus segregation and slavery are diametrically opposed to Christianity. Thus, he calls the church a buffer against the angst of racism. Thank you.
Thank you so much. I'll turn the time back over to Professor Scharf if he has any other last words.
Thank you very much, Professor Barclay. We have one more speaker who was in a court date, and I'd like to give him an opportunity to make his presentation. Matt Cavedon.
Thank you very much, Professor. I was late this morning very uncourteously because I had to be in person for court. And that's a bit of a rare thing these days. Most court lately has been done just like what we're doing right now on Zoom. But this actually proved pretty fortuitous in that my piece is about the importance of physical presence in court and church. It's interesting that even as technology is progressing every single day, every single year toward more and more virtual reality, toward being online, even though this seems in many ways to be such a culmination of our achievements technologically as a species, we don't seem to like it all that much. I think we'd all much rather be in a conference room with finger sandwiches waiting outside. I think that most of us would rather be in person for court, for church, for religious, for other reasons, rather than online. Why? In a certain way, this is about the most obvious kind of post I possibly could have written, and yet it doesn't seem obvious. in that everybody over and over again talks about the inevitability of what's happening as more and more things move into the cloud. Some transhumanists are even talking about uploading our entire consciousnesses to the cloud and simply having a virtual life. Anybody who's watched Black Mirror knows that they've created entire alternative universes where bodies simply aren't there. Nevertheless, again, even dipping our toes right now seems to be such an awkward and uncomfortable thing. There are two big bastions of resistance to this technology trend. One is the one that I just got out of about 10 minutes ago, and that would be courtrooms. And the other is churches, both of which have been very, very hesitant about the shutdown and have very actively protested to try to open back up and get back in person. Once again, why? I think that our current predicament shows us something very real about ourselves, which is that despite what so many philosophers have said over the past couple hundred years, we're not just brains in a jar. We're not just blank slate minds that get information and we're rational thought computers and we do our thing based on that. We're also bodies. Our minds rely on our senses. Our embodiedness affects our ability to pay attention, to process information, to encounter people, to express ourselves, to do all those things. And so I submit that even as everything gets zoomier and zoomier, you're still going to see court and church and other key institutions insisting on getting out of bed on a Sunday morning or getting up at 9 a.m. and being there in person, because that is part of our personality, is to be both body and mind present. So thank you for letting me be a part of this.
All right, thank you very much, Matt. Well, we've witnessed something I didn't think possible, 25 academics who exercised restraint. I'd like to thank all of our panelists for their contributions. My reaction, among others, has been to see that there is a wider and more varied set of issues than I had realized. The presentations have been a set of snapshots. I hope many of you will be motivated to dive deeper by reading the blog posts that will be posted on the blogs of the sponsoring centers. I also want to thank everyone who has participated by listening, and also those who have provided technical support behind the scenes. One thing we are learning is that this pandemic will last longer and have longer lasting implications than we thought 6 months ago. Please stay safe and well. And as Tiny Tim says at the end of A Christmas Carol, God bless us, everyone. Thank you. We are now finished.